Departments and Institutions Committee. We're back at 1 o'clock here on Wednesday, January 29th. Today in the State House is Mental Health Advocacy Day, and we have some folks here who are visiting our committee this afternoon just to give some brief testimony, updates, weigh in on issues that folks pertain to. So we have Kristen Chandler.
Thank you, Madam Chair.
And I'm going to turn it over to you. So if you could identify yourself for the record.
I'm Kristen Chandler. I'm the Vice Chair of the Mental Health Crisis Review Commission. I'm here in that capacity today. And I really appreciate the opportunity to be here as part of Mental Health Advocacy Day because our report that we write once a year, hot off the press yesterday, just became public yesterday. And there's a particular case that we looked at that has some recommendations around corrections. So I think it's very, opportune moment for us. So the Mental Health Crisis Review Commission was created back in 2017 by the legislature to review any incident that involved a police officer and a person with perceived mental illness that resulted in either serious bodily harm or death. And I am one of two commissioners who's been on the commission since the inception of it in 2017. It's made up of 11 people. You're probably people you would assume would be on from the Department of Mental Health, Vermont State Police, Chiefs Association has a representative, NAMI Vermont, Disability Rights Vermont, Psychiatric Survivors is also on there. The Attorney General's Office is present in the Criminal Justice Criminal Justice Council. And then there are two at-large members, and I'm one of those who were appointed by Governor Scott. And I was appointed in my capacity as coordinator of Team 2, which is a statewide training on mental health response for law enforcement, mental health crisis clinicians, EMTs, and dispatchers. That's been a joint effort between the Department of Mental Health and the Department of Public Safety for the last 11 years. So in that capacity, as the vice chair, we really wanted, the commission wanted this committee to be aware of the report. I know you get a lot of reports that are required by various commissions. I don't know how they ever filter down to you, but I just wanted to draw your attention to this particular case that we looked at two cases this year, one of which came out of Ludlow, where a young man was killed by a Ludlow police officer. And while the report doesn't name names, so it's a small enough state that some of you are probably really familiar with what I'm talking about. And the real particular thing about this is there was a real intersection of probation and the mental health system, because the individual, he was in his 30s, he was on probation at the time. Probation had been transferred from New York State. Was working closely with his probation officer, making his appointments, but he suffered from mental illness. And it was really hard for him to understand the conditions. He really rebelled against them in some ways. We interviewed, as part of the review of this case, we interviewed 4 different probation officers and 7 different people from healthcare Rehabilitation Services, HCRS, where he was receiving treatment. And so we interviewed his mother, we interviewed his best friend, part of what we do in our role in reviewing cases from a really systems overview to see if there's anywhere along the continuum where something may have made a difference so that this incident wouldn't have happened. And we really got a good picture of, and an education on the probation system and on how it intersects with mental health. And what we came away with really is one of the recommendations, and this is a 28-page report, and I'll just turn your attention to page 26, where the recommendation specific to this case, to your committee, is where somebody in that kind of a situation where they're suffering from a mental illness and they're trying to navigate probation and conditions of release needs an advocate, needs somebody with them at their appointments, needs somebody to help them, regurgitate them afterwards and kind of figure out how they're going to be in compliance while still navigating, multiple systems in working with their illness at the same time. And that's what this particular individual just had very hard time with law enforcement in general, but also just really didn't understand why he wasn't allowed to have a job, why he couldn't have his girlfriend living with him, things that he felt like would make him feel more part of his community and would help him in his recovery and his mental illness. They were conditions imposed by New York, but transferred here to Vermont, and attempts to explain them by his Vermont probation officer. He just, in that meeting, those half-hour meetings or however long they are, it's just really hard to, figure all that stuff out. And we thought that having somebody present who could help him or help an individual in that situation, go back over those conditions, really think about how you can be in compliance would be helpful. And there is currently the support services for people who are going through the court system, who may have intellectual disability or just have some cognitive issues where they need some help navigating the legal system. And we thought in our recommendations, let's take a look at that and see if that program could be bolstered to include assistance at probation, in particular probation meetings. And when we talked with the probation officers, they all welcomed this idea because they were sort of almost as frustrated as this individual was, because they understood the reason for the conditions and they really wanted to work with him. They didn't want to set him up for failure. And yet, just because of that, his mental illness, it just was really hard for him to understand what was going on. So that's really our recommendation.
So I have a question on this. You said that the probation of the officers in the field office as well as HCRS. I'm assuming this is Springfield.
Yes.
MP as well. HCRS is based in Springfield. Was there any indication that if information could have been shared between HCRS and the PNP office, that things might have turned a little different?
Well, things were shared. I mean, there is a system
So
for them to share.
HIPAA did not rise to the.
No, and that's a great question, Madam Chair. HIPAA did not. We asked about that as well, and HIPAA did not interfere with that communication. But we did talk about, do you need more opportunity to interface between his clinical team and his probation team? And everybody said yes, that they used to do things like that, where they would get together and learn how each other did their job, and that's kind of fallen by the wayside. And they really would welcome another opportunity to sort of revitalize that. And I, frankly, Morning Fox is on the commission with me. You might be familiar with him. He runs mental health programs for the state police, and he and I do a lot of training together at the police academy. And he's one of my instructors for Team 2. And he and I said, we could easily put on a training for probationers, just a mental health 101 basic training, but also bring in whoever their mental health counterparts are, in whatever part of the state, so that they could train together and learn about each other's limitations and, just how they do their jobs.
So when did these interviews take place? Like during this past summer and fall?
The interviews that we did with the probationers,
Yeah.
they're listed actually on, hang on, let me get to that, because there's two different people two different cases we looked at. So this case starts on page 16, and we interviewed them.
So this past year or the year before?
Yeah, it was all in March and April of 24.
Okay. I'm asking this because there has been a lot of work in the past few months between HCRS and the local PNP office.
Fantastic.
To bring together, because that has been a concern. We used to be able to do this. And the big issue that sort of rose up was HIPAA. And the PNP is saying, well, we don't need to know all the medical nuances. We just want to know, is the person doing the treatment it's supposed to be doing? Is he complying? Is the person complying? And what they've started to do is PNP is going up to HCRS, hopefully, to introduce the folks who are working there that this is what PNP.
That's great.
So there is some of that has
Started to happen.
started in the grassroots,
That's great.
Down
Do you
there.
know what the impetus was for that?
Project Action,
Okay, nice.
Project Action.
Okay,
And a
great.
committee that's set up to kind of look at crime and safety, and this is one of the issues
Yep.
that came up
Nice.
with that.
Will we be able to get an update on how far they've come along, or is it too soon?
It's too soon. Yeah, that's way too soon for that. But, and I wonder if it's also a result of your case that you were.
Well, as I said, this really just is hot off the press yesterday, so it's all of our meetings are confidential, so nobody would have really known about that. One of the other people on the commission is a representative from the designated agencies and from Vermont Care Partners, and our current rep is from HCRS. But so she had to recuse herself from this particular case. So we had somebody from the Howard Center instead fill in. So they also were not privy really to what we were talking about until yesterday.
No, it's been in the works of trying to get those two entities together since August,
That's great.
September.
Good.
So questions? Sure.
You said, you've had two sort of, I don't know, do you call them cases, investigations?
This year, we have to write a report annually, so
Yeah.
we have actually done a complete review of now 4 cases, but this year we did 2 at the same time.
So yeah, I guess my question is, how does that compare to either recent years or historically? And how do they get to you?
Okay, great question.
Yeah.
Police chiefs are mandated to
Okay.
forward their cases that involve somebody with a perceived mental illness and death or serious bodily injury to the Attorney General's office.
Okay,
And we only review them once a complete criminal review has happened and the use of force review has happened.
Yeah.
So there's no issues there as far as, getting access to the discovery.
Right.
What's interesting, so that's mandated by the statute, that they have to forward those to us. What is discretionary for them to forward are cases where there's been a good outcome, where they think, the state, other people in the state may learn from whatever they did right in that system or in that particular scenario for a systems, for everybody to learn from it. And I've begged chiefs all over the state, because that's what, with Team 2, I interact with them all over the state, and we have yet to be given a case where there was a good outcome, even though I am very aware from my job that there's all kinds of great outcomes happening all over the state. Really good collaboration, really good diversions from hospitals or from just spending the time to talk to somebody instead of just rushing forward and having to use force. So that's how we get the cases. And the way it compares is when we started in 2017, the commission was created as a result of the Phil Brennan shooting, which happened in Burlington. And so that was the first case we looked at. And then we had a little bit of a backlog. We had a bunch of cases from like 3 or 4 cases that we looked at where people had died or had really been sort of asked police, put themselves in a position where they wanted police to shoot them. And some of those, they didn't really have a mental health component to them. We have some criteria for what actually constitutes that. And so it wasn't until this year that we had 2 cases at the same time. Because we've looked at probably, I want to say 8 or 9 cases, but we've only done a full review on 4 of them. And we have 1 currently for this coming year.
and how confident are you in the reporting structure? Do you think you're getting what you should?
We definitely are. We have subpoena power, but we haven't, most people are pretty cooperative. And because we're not looking to point fingers. We
Yeah.
really want to just see, is there somewhere where either training or policies or something would help?
Right.
So it's really to everybody's benefit. We are very sensitive about putting people back through the trauma they've already been through. So some of it, we look to families now. We reach out to the families and say, hey, we're going to look at this case, and if you want to be involved, we'd like to talk to you. And we've, for some families, they haven't wanted to be involved. And so there, we don't get the full, picture of the individual that we would like to, but, we certainly understand why somebody may not want to participate.
It's a very serious situation, so I don't want to assume. What I'm hearing you say about the Ludlow situation was that if the officer involved understood the situation better, death may not have occurred.
No, no, not at all.
Okay.
That's not our finding at all.
That's
Not
fine.
saying that. Mm-mm.
No, there was no, finding of anything that would have helped the officer not be in this situation.
Okay.
No, this is an individual who, started off that particular day asking the police to kill him and telling them that he wanted to die. And they did everything they could to try to, keep that from happening.
Good. I asked the question.
One thing that has been a common theme, basically kind of going to your question, is this is the second case where we found that somebody who is actually legally prohibited from having a firearm has had a firearm. And while we know, people who've been committed to the care of the custody of the Commissioner of Mental Health aren't allowed to have a firearm, there's all kinds of ways, to legally buy one. There's all kinds of ways for people to get access to a firearm. And that unfortunately was the case for this young man as well. And we tried to track that down, but where that came from, and I ran into a dead end. But, it's not that hard. We've learned it's not that hard to find a gun on the street, or if you want one.
So then I guess I am still confused. If it wasn't a lack of information or understanding on the police officer's part, how would communication have, your recommendation is better communication between the two groups, what I'm hearing.
My recommendation it's really for a better communication for a person on probation who
Right.
also has a mental illness,
Okay.
to have an advocate with them at their appointments and to debrief with them afterwards to sort of figure out, to explain what the conditions are and make sure they're going to be in compliance, but also help them manage
Okay.
their mental health. And we suggest in the report that it could be a peer position. So somebody who has been through either probation or currently has identifies as a person with lived experience or a peer living with mental illness, who could be that person.
So support for particular events in their life,
Yes, yeah,
not 24/7 care, but.
no. In particular with the probation, going to those appointments, which generally, I mean, in this case, I think they were once a month. The other piece of it, though, is this is somebody who lived in Cavendish, very isolated, rural community with no transportation, not allowed to drive because of his criminal convictions. Just a combination of factors made it really hard for him to access services. But he didn't really want services. And so when we looked at it, like everything possible, I think that HCRS could do was tried. And also the embedded police mental health social worker had worked with him several times to try to help him, because he had what he did was he called 911 a lot, like 90 times a day, because that's how he sort of got out his frustration towards the legal system, was by calling 911. And so that's one of the uses for the embedded mental health workers, is just to try to help somebody, figure out why you feel the need to do this, and let me help you. And so it doesn't tie up the 911 system, but also maybe could help that person as well. And that was true in this case. And they had a pretty good relationship, but it was just really hard.
So obviously he was designated as potential harm to himself, but not others, because he had been released from New York.
He was, because he lived in Vermont, his conviction was from New York. But all his ties were here. And so New York transfer and Vermont agreed to take him as a transfer probation. Yes. And he was connected with HCRS.
It's just the crime occurred in New York.
Yes.
So was there another case that you wanted to share with us, or was that?
No, this is the one that really pertains to corrections.
Corrections.
So, any other questions?
No, but I would appreciate it if you could send that report. I like the
I
pages.
sent it yesterday,
Okay, I'd
but I can certainly highlight the pages.
like to know which page. It's 26, 27.
Yeah, yeah.
It doesn't appear on our calendar. As far as testimony, I don't believe.
Well,
What's that, am I missing it?
I don't believe the report was submitted here. It was report, who was the report submitted to?
I thought to you, wait, what's your,
okay.
Bill Petty?
yes, at ledge.state.bt.
And I missed it and it will be posted.
Okay,
Yeah, and maybe just, we get a lot of emails.
I'm sure you do. I do have some hard copies if you want that, but I thought you preferred it by electronic.
I would take a hard copy.
Okay, you bet. Okay,
Yeah.
thank
Any,
you so much for having
Thank
me.
you.
any other
Thank you.
questions? Do you have anyone else here that was thinking of testifying at all, or you just brought folks in to see how the system goes?
I didn't bring anybody with me. These folks are here on their own, interested in mental health advocacy, I think. And this is what, you were one of the committees that was offering a time slot.
Okay, great. Did anyone want to speak up, or are you just checking in? Sure.
So, it's been some time since I've heard news of, the program for peer support ride-alongs with the state police. I'm wondering generally if that has increased numbers of cases that has come to this commission
Don't know.
Peer support ride-alongs.
for the state police.
Yeah, I don't know
Oh.
anything, I'm sorry, I don't know anything
That's
about
okay.
that. Yeah.
Okay. I wasn't sure if instances of,
We have one.
such as welfare checks or, entry into the mental health system through the police system is under the purview of this committee. I guess I assumed that was.
Not really. That would be under Judiciary Committee, more under for state police. We deal more with the Department of Corrections, that piece. But it would be
Do you want-
Judiciary Committee that's
You want
more
one?
with the law enforcement and what's embedded with our state police. I guess everybody wanted paper copies.
There we
That's cool.
I thought, this isn't the mental health crisis response commission.
She,
I'm on the Crisis Review Commission.
Okay, I'm taken. Thank you.
that's fine. That's fine. We're a legislative committee that just deals more with corrections. Judiciary Committee in the legislature is the one that deals with the state police and who would be embedded in the state police.
Thank you.
Oh, you bet. My pleasure.
Anything
Thank you.
else for folks?
Thank you so much. Thank you.
Thank you for this.
Good day.
You as well. Right.
Way to go. Poor fellow. Trying to do his job.
And then I'm over here knocking down. Are we still live?
Yes.
Oh, we are. Oh, no, we were taking a recess.
Yeah.
Live.
We're live.
This.
So Mary Jane, you're here. Is Dean on Zoom? Is he? Dean?
It's been good. It'll be so good to see him.
Okay.
It's nice to see you.
I heard a bing bing.
Does that signify anything? That would be in the BE zone?
A bing bing means somebody's coming online on Zoom.
I wasn't being facetious.
No, it means someone's coming on Zoom.
And there he is.
Bing bing.
Thanks for Gina.
Okay,
Jean.
we're gonna shift gears. This is gonna be more of an educational, bringing new members of the committee up to speed in terms of the parole board, and parole. Parole is a little different than probation. Probation is under the courts. Furlough is under DOC. And parole is under the parole board. And we have with us today the chair of the parole board, which is Dean George. Welcome, Dean. Dean was a former member of the House from Middlebury. And then
Thank you.
the director of the parole board, Mary Jane Ainsworth. So we have a new committee. We have 6 new members to the committee. I thought it would be a good opportunity for folks to hear what the parole board does, your structure, what parole is, how you work with DOC, how DOC works with you. And just really have an open conversation so the committee members can understand the differences between probation, furlough, and parole. And I'm sure you're also going to get into presumptive parole, I would assume. So that's something new that the committee has not heard about yet. So, Dean, I'm assuming I start with you.
Thank you. Good to see you again. And good afternoon, everyone. So Mary Jane has put together another PowerPoint, which kind of goes through the dynamics of what the parole board does and how it schedules its hearings and conducts them. And I think it might be helpful just to quickly review that, and then we can deal with questions that come up on other issues following that. There's been quite a bit of work in the last year and a half, particularly with some of the processes that the board uses, in particular our structured decision-making framework, which we can get into a little bit. The complexity of the hearings, it's changed a lot in the last 2 years for us and how we're dealing with that. But I think it would be helpful just to do the overview first, if that's okay.
That's fine.
And then we'll go
Do
from
you
there.
have to share the PowerPoint? What?
I have it. I don't.
Give you that permission in a second.
We're juggling a lot of things at once.
I understand completely. It's always juggle everywhere.
Juggle a lot of things. So bear with us.
Is
Is this the presentation?
Yes.
Okay.
Mary Jane, I need to send you a link.
Okay.
And you'll enter into that link.
Pre-trial supervision.
Thanks, Phil.
Not
No,
this
not
one.
this
No.
Sorry about the name under mine. My wife used Zoom last night for her Porter Hospital board meeting.
I'm giving some, it's wonderful.
It's sent.
As soon as I get it.
So I may be stepping out for a little bit because I have to meet village council on one thing. He has a minute to come over. So if I walk out, you can keep running the meeting, but whenever he comes over, it won't be long. Okay.
So while MJ's doing that, I can just quickly cover the nuts and bolts. We do 10 hearings a month that are scheduled Tuesday, Wednesday, and Thursday of the first 3 weeks of the month, and then a Thursday on the last week for an overflow day. Typically, we'll have to juggle a schedule sometimes to accommodate last minute demands for hearings. And we have a staff meeting on the last week as well. So for the most part, the hearings are conducted Tuesday, Wednesday, and Thursdays, 3 weeks. And then in the last week, we have an overflow hearing date of Thursday. And there are 7 of us on the board, and 3 of us participate in each of the hearing dates. So we kind of rotate around with either myself or the vice chair is at all of the hearings, and then the rest of the board members fill in the other 2 slots as we schedule our hearings. And typically there's information that's provided to each board member ahead of the hearings. So board members have usually a day's worth of homework before each hearing that they handle on their own at their homes usually, and get prepared for the hearings individually. Here we go.
So I think one thing too, before we get into the hearings, these are for folks who are incarcerated and they have met their minimum. Once they meet their minimum, they are entitled to a parole board hearing. And if they are not paroled, how often do they go before the board for a hearing? Once a year,
Yeah,
twice a
the
year?
most, the most would be once a year. We review each case annually. As you recall, it used to be 2 years if they had a 15-year or more sentence, and 1 year if it was a misdemeanor case versus a felony and that sort of thing. But that all got cleaned up by your committee a couple of years ago, so that every case that's not on parole that is still eligible is reviewed annually by ourselves, and the Department of Corrections can bring them forward at any time. So there's quite a bit of flexibility there. And I think that's covered pretty well in this thing too, which would be helpful to see.
Mhm. So.
MJ, do you want to proceed with it?
Sure.
So why don't you kick back, because I know you went up to the parole.
I went up to
Yeah,
the parole because I was,
go back to the hearings will be fine.
for the record, I'm Mary Jane Ainsworth. I'm the director of the parole board. So as Chairman George was speaking, we hold all of our hearings virtually every month. Having them virtually allows us more flexibility, as we schedule each site for a specific day. However, if something arises, we can move folks between hearing sites if we need to. We could have a hearing earlier or later, depending on the specifics of the case. We hold multiple different types of hearings, as we will be talking about today. Each slide kind of goes through every type of hearing, so I may not go through every single one right now. We'll go through them after, as we're going through. In 2024, 694 individuals, whether they were incarcerated or in the community on community supervision furlough, came before the board, or parolees, I should say. This is how many actual hearings we had with individuals of those different types that we just saw on the previous slide. And we'll go through specific numbers. In addition to this 694, we've had 152 individuals waive their hearing. You can waive your hearing, you can waive your initial eligibility hearing or your parole violation hearing. So we had 128 individuals choose not to come before the board for their initial eligibility hearing for various reasons, and 24 individuals who waived their parole violation hearing.
So I'm really seeing you had in 2019, 976 individuals. You're about almost 300 less. Is that because the population of folks being incarcerated has dropped?
Yes, significantly. Yeah.
Yeah, I think it's due to that. And I think also some of the other justice reinvestment initiatives around pretrial and diversion and probation, all the initiatives combined. We've been seeing this trend.
And are you seeing a trend of the 694? How many do you have? How many of those were condition violations?
I will have those numbers are further in the presentation.
Got it.
So as we started to go through the parole process a little bit, there are 4 different mechanisms or ways that a person can be granted parole. The first one is presumptive parole, and I'll get into more details in that with some data in a couple of minutes. This applies to individuals who they get screened prior to their minimum release date. So presumptive parole only applies to those who are prior to their minimum date. And then we also have the initial parole interview, which is these are the individuals who are not eligible for presumptive parole. They are coming up to their minimum. This is their initial eligibility hearing. Also, this applies to individuals who received a zero minimum. So they have up to 12, the Department of Corrections says up to 12 months after their sentencing date to bring them before the board. And also for offenders who are designated by the Department of Corrections as a high-risk sex offender that have to complete at least 70% of their maximum sentence. So we do not see them until that 70% date. Then after you have your initial eligibility hearing, there are multiple ways that you can get on parole afterwards if you're denied at that initial hearing. Every year, we do annual reviews per statute. We call them record reviews. And at that time, an individual can request to see the board to be interviewed for that review versus generally these reviews are paper reviews, file reviews. The board will look at, see how the individual is doing, what they've been doing, and then they will either process the record review if they feel that they should continue to not be on parole, or they may request that the individual appear the following month for an interview for potential parole placement. Also, the Department of Corrections will request a hearing for individuals and request that they appear before the board, recommending them to be placed on parole supervision. So, and then there's medical parole, which is really been non-existent at my time with the board. I think we've had one medical parole case come before the board in the last 6 years while I've been there. And those are more of the person has to have a serious medical condition that would render the offender unlikely to be physically capable of presenting a danger to the community in order to be released prior to their minimum release date.
We're gonna have some questions.
Yeah, of course.
I have a question. With medical parole, and I don't know, maybe it would have fit under that category, but has it in the past historically, maybe not now, but has it ever been used for people that are seniors in like in an older age category?
Yeah.
And DOC doesn't want to have them in their system and not want to handle them, so they just release them to kind of get rid of that problem. Because I have a family member that was released in their 70s because of that, not in Vermont, but elsewhere. And I'm just curious what Vermont DOC policy is with that.
If I can speak to that, it's been rare that medical parole has been presented to us, but when it has, it's typically for someone who has some type of a debilitating health issue that can't be managed in a facility, or it's such a point in time where it doesn't make sense for them to remain incarcerated, but they're not yet eligible for parole. So if there's some medical reason that can be documented and presented to the board, then the board can grant them medical parole. And typically there's placement in some kind of a assisted living home or place where they can be having their health care managed while not being incarcerated. But they're very rare cases that come before us. But whenever they do, we certainly schedule the hearing and try to accommodate that.
Thank you, Chair George.
So there's also a step before that DOC may do before you get to parole would be medical furlough. And that's through DOC, and DOC could furlough someone to a medical facility or a family member's home, but they would be under furlough, which is a little more stricter supervision than parole.
Well, that's part of what's been going on in the last couple of years, Madam Chair, is that, as you know, we've been trying and working with corrections to lessen the number of people on community supervision furlough. And there has been a change in their dynamics where they recognize that someone in the community should be supervised by their risk and not by their status. So in an effort to reduce the number of people on community supervision furlough, it makes sense that they would be either on parole or not on parole. But if on parole, then their management would be determined by the risk that they pose in the community and not by their status. So the old adage that they should be on furlough because they're supervised more closely doesn't apply. And it gives us more flexibility to place those folks in other areas, particularly if ICOTS is being used and we're looking at supervision in another state. Makes sense to have that. And that's been working. The transition's been slow, but it's been, I think MJ has a slide in there a little later on, that the huge difference in where we were just a few years ago with the number of people on furlough versus parole. It used to be somewhere around 1,000 on parole and 1,100 on furlough. And now that number on furlough is, I believe it's around 150. And we're somewhere around 800 people on parole at this time.
Thank you.
So we have another question, Kevin?
So we just heard testimony of a very unfortunate situation in Ludlow. And maybe he was not on
He was
parole,
on probation.
he was on probation.
That's with the
That's totally
courts.
different
Mhm.
Yep.
It's with the courts.
with the court.
Probation is totally different. That's a sentence. Parole is not as,
Right. No,
it's not a sentence.
I'm with you.
It's
We
a
would get them-
supervision and a status.
Just check.
We would get them if their probation was revoked and they were sentenced, then they would be eligible for parole after that.
So his status was different, but
Yes.
he's calling into 911 repeatedly for a long time.
It's probation. It's
Yeah.
to the courts.
Right. So he drops through the cracks because he hasn't been,
He dropped through the cracks because of his ability to, with the mental illness, comprehend the conditions that the court set on his sentence, and then carrying through on that. That's where the
Yeah.
breakdown came.
But right now, we're dealing with
That's
parole.
right. But he
Parole
wasn't,
is
so he wasn't sentenced in New York then either.
His crime occurred in New York. He was a Vermont resident, from what I understand. His crime was committed in New York, so it was adjudicated in New York. The New York courts put him on probation with conditions that the New York court placed on him and agreed that he could live in Vermont, but had to comply with the conditions that the New York court put on. So that's different than this completely. Impact.
Nice.
I know they both start with P, but they're very different, and the public confuses it all the time.
Yeah.
All the time.
You were my quotes today.
Hmm?
Shall we proceed?
Yep.
Yes,
Thank you.
So as you can see, since 2019, we had a pretty dramatic drop in the number of parole hearings. And when I say parole hearings, this is those that are coming before the board for parole. This is not the condition, this is not a violation, this is not a condition modification. These are the initial eligibility, the presumptive paroles, the subsequent paroles that I was talking about in the previous slide. We have seen an uptick since last year. We've started to go back up. I have a feeling, and my best hypothesis would be that the courts are starting to catch up.
Mhm.
And this number most likely will continue to grow until that backlog is taken care of.
Mhm.
But as you can see, the granted is in blue, the denied is in green. We're granting more than we're denying every year.
I'm assuming you're going to get into what information is given to the board at the hearings. And where that information comes from, and DOC weighs in. Because that would be really, it's not just kind of a flippant in and out.
It does look like the last 3 years that there are a higher percentage that are denied than there were in the previous 3 years. Is that because of maybe the type of crime, or are there different members in the parole board?
Do you have that
Well,
breakdown, MJ? I don't have.
I do
it in
not,
front of me.
I don't have the breakdown. I don't have the
Yeah.
percentage breakdown.
I would say definitely that's not the case. The board members, every year there is 1 or 2 new board members that get introduced into the board, and we spend a fair amount of time with our training process. And a number of those, I think it's fair to say over the last 3 years, the cases that we're seeing now are much more challenging, and the crimes, the easier ones to parole are no longer there. They're already in the community on different, either probation or another fashion. But the ones that are challenging, typically, if they're not ready for parole and parole is denied to them, we give them a clear path forward as to what they need to do to be ready for parole and how we get there. A lot of them have committed new offenses, and we will get into that, I'm sure, on the violation phase of that. And so we're dealing with those cases as well at the same time. But as far as why that number is higher than not granted, I would have to say that it's more likely than not because the cases are much more serious by and large.
Could I add just real quickly? I think also to add to that, we're seeing more. I don't have specific numbers, but I feel that more are coming to the board who have adjudicated maybe one charge, not all of their charges, so they have a new minimum for that new charge, so they're coming before the board, but they still may have another detain, and they might be being held or detained on another charge. So I think that's one piece. Folks still they may have been out in the community and had their parole revoked or their furlough revoked, and they're getting a reset in the facility, whether that's additional programming or so forth as well. I think it really depends on each individual case, and the cases are a lot more complex.
And so to that point, the chair just mentioned to bring up that is it more looking at the crime, or is there more significant risk factors?
We do a pretty comprehensive analysis for each case with our structured decision-making framework, which looks at a number of different things, which we can talk a little bit about at some point too, including the seriousness of the offense, what programming may be needed. But ultimately, as MJ just said too, a lot of these folks that have been picked up on new charges have not resolved those new charges yet, and may still have a minimum date or a date that they need to be seen by the board. And the board is not going to be paroling them if they still have pending criminal charges to be resolved. We want those to be resolved first, and then we'll move forward with parole after that.
Makes perfect sense. Thank you. Continue. Appreciate it.
And kind of it's a little bit, as Chairman George has already spoke a little bit previously, we did have some changes to parole supervision through the Justice Reinvestment 2 legislation in 2020. One of the goals was to decrease the number of individuals on furlough supervision and increase the number of individuals on parole supervision. As we've spoke to that is already happening. Also, Department of Corrections has changed their policies and are now supervising all individuals by risk level, not by their legal status. Before, parole was considered more of a step down status, and it was more looked at if you were on parole, you were going to have less conditions, you potentially would be on telephone reporting. That was the notion of parole before. Now it's by risk. And also, Justice Reinvestment instituted presumptive parole.
Will, you have a question?
Could you explain kind of that difference between the legal status and the risk level a little bit more?
Yep. So before community supervision, furlough had one level. It had however many checks they would have, how many times they'd have to report. The individual would have to report to the office. It would be one number, and then parole would have another number. Parole would be significantly less than the furlough. And now they look at the overall risk of the individual and determine the number of checks based on their risk, not based on whether they're on furlough or parole.
Okay.
Also, back before that as well, most of the cases that the parole board saw were people that were already in the community. So it made our jobs pretty simple in the respect that they've been in the community, they've been supervised in the community by corrections on furlough, and now they're ready to step down to a lower supervision status and be on parole. So we have a history of how they did in the community. Whereas now we're seeing a lot more folks directly in the facilities and preparing for their supervised release on parole as opposed to community supervision on furlough.
Thank you. Get that one?
Yep.
Okay.
So presumptive parole. Presumptive parole was created in the Justice Reinvestment Act, as I stated a minute ago. For the first 2 years, presumptive parole only applied to individuals who are not serving a sentence for a crime specified in 13 BSA 5301, what we call the listed offenses.
So 11 or 13?
No,
No.
that's that the listed offenses are more in the victim statute around. It's more the more violent crimes, and it's a bigger list. I don't have all of them off the top of my head. But usually it's a crime against a person.
Thank you so much.
Yeah. And then beginning in January 1st of 2023 is when we expanded to include listed offenses, except for what we used to call the Big 12, which I now think is the Big 10 or 11. When I looked at the statute last night. So as you can see, at first, presumptive parole, we had a lot more presumptive parole cases. We've gone from 12 in 2021 to 4 in 2024.
Sorry.
No, you're fine. So presumptive parole, I think if you really look at the numbers, it has dropped drastically over these last few years. I used to have time to look more at the specific cases who are coming before the board to try to figure out why they weren't eligible, why they might not be eligible for presumptive parole. And as I get through get into it, Department of Corrections is the one that determines the eligibility. So I don't know if they track those numbers or not.
So did you, I'm sorry, I had to step out. Did you explain that presumptive parole is instead of furlough? Sort of, it's presumed, when you read the thinking behind presumptive parole, at least on the legislative end, when this was put in place, was when you reach your minimum, you are eligible to be furloughed. Doesn't mean you will be, because it's based on a number of factors. We have changed that for some crimes, not all crimes, but for some crimes, that once you reach your minimum, you will be presumed to be paroled instead of furloughed. But there are conditions to that in a way, in that it's not an automatic. You still have to go before the parole board. It has to be on recommendation of DOC. DOC can say, no, this person's not a good candidate for parole. We want to keep him or her on furlough first. So that was and the initiative for that was, there was so many different types of furlough that DOC had that it was getting really cumbersome on DOC's part. And we worked to really consolidate the different types of furlough, number one, but also we wanted to keep moving people through the system. And if eventually they're going to get there to parole anyway, let's just presume that they will be paroled, because most other states do not have furlough. They have probation, they have incarceration, and from incarceration you go to parole. They don't have furlough. We're a very different state that has furlough, was that intermediate. So we were trying to also model what other states do.
Right.
So that's the thinking behind presumptive parole.
That number has gone down dramatically, as we stated too. It's been amazing in the last couple of years.
So so to kind of go along with that, the number of individuals who are going from incarceration to parole in general has increased dramatically. I don't have the exact numbers, but the board is granting folks from the incarceration. The goal is to grant somebody, if possible, parole out of the correctional facility instead of placing them on furlough before they come before the parole board. And that has been happening.
So you're sort of doing presumptive parole automatically in that when they become eligible for furlough, they have a hearing for the parole board anyway.
Right.
And you are paroling them.
Yes.
Questions, Joey?
Friday, we received historical data on the number of people detained and sentenced. And then we received, I believe, from Mr. Turner, in reference to the out-of-state program currently in Mississippi. And then we received current data on why people are in one of those statuses. But if you, I believe increasingly so, if people are being detained or sentenced for one of the 13 major crimes, which may just, I think plays into the possibly
Yes.
why maybe the denial rate has increased in hearings, that would be the inference possibly, which I think you already, but there's just data from Friday that kind of speaks to that, that's all.
And I can also speak a little bit. So presumptive parole has 7 eligibility criteria. I just put that up on the screen. And for the most part, most everybody and most individuals who are coming before the board for their initial eligibility hearings, is presumptive parole kicks in prior to the initial eligibility hearing. Everybody is reviewed for presumptive parole. And then if they are not eligible, then they come before the board for a formal hearing. The majority of the individuals do not meet these criteria. They hit one of these criteria, I should say, one or more. And the most frequent ones are, most individuals we're seeing have acquired a new criminal charge while they've been incarcerated or on supervision for their current offenses. That is frequent, which in turn, a lot of times they've been on parole for their current sentence and they picked up a new charge, and therefore they've had their parole previously revoked. We're also seeing with the increase with the illicit offender population, what I've seen is there's a lot that are still in programming when they come before the board. So that makes them ineligible for presumptive parole. Those, I think, and then major DRs comes into play too, because 12 months, there's a lot that have had a major DR within 12 months. So I think those are the big factors to why we're not seeing the presumptive parole cases.
And those 7 situations were put in there as safeguards.
Yep, absolutely.
That's why they were put there.
Yep. Absolutely.
So we didn't want to open up the floodgates. And those were safeguards that we put in statutorily.
And those
Aaron?
people are still going to be paroled. It's just that they have to go through the hearing and they're not presumptively paroled.
Right.
So it is likely that you're not going to be able to answer this question. But a couple of weeks ago, we had I should say a case that was coming out of corrections with someone that was going to be let out into a community. And this was somewhat of a person that continued to recidivism for fairly serious crimes. Were you in any way a part of that, or was it in only the first stages through corrections and deciding if this person was going to even be eligible?
Yeah, I'm not sure, Mary, which case you're talking about, but if it was one that was highly publicized,
Yes.
where corrections was looking for a residence, we had seen that individual prior to that and had denied parole.
You had denied? Yes.
Parole was denied. Now this goes back, I think they were trying to furlough
Yes.
persons. So this goes back to really understanding the difference between furlough and parole. Not only do they answer to different folks, furlough would answer to DOC. Furlough conditions are set by DOC. Parole is granted by the parole board, and conditions are put in place by the parole board. The thinking is with furlough being under corrections, there's a shorter leash to that person. They can bring them back into the incarcerated facility quicker than if they're on parole. If they're on parole, they have a little bit more flexibility and freedom while they're out in the community versus being on furlough. On furlough, it's a little tighter. They don't have as much flexibility, and DOC can bring them right back in if our field officers find that there's a valid violation of conditions. With a parole, it's different. They have more freedom, more flexibility. They would be allowed to go out of state in some cases. Furlough, you're not. So you don't have as much supervision when you're on parole as you do furlough. And that's important to understand that. And that's why the person was probably denied parole, but could still be furloughed because there would be tighter supervision for the person on furlough.
So we hope.
So that's important to understand the difference between furlough and parole.
I think another important distinction too, is that people who are being supervised on furlough, if there is a violation, are entitled to due process. And there has been a number of cases that have been litigated around that issue as well, which I think the legislature was trying to address back then as well, to reduce the number of people on furlough to afford that due process right to those individuals that were being accused of violating their conditions of supervision.
So in essence, for presumptive parole, what is happening is when that was first put in place, there were more folks that really were eligible for it that could meet the criteria than what is now currently our incarcerated population. So you're presumed to be paroled when you meet your furlough, and you could be released without a hearing. Is that correct? Or do you need a hearing?
No, it's without a hearing, it's an administrative review, and I think that the key difference between presumptive parole and your initial eligibility for parole is that hearing. It's more of an administrative review on paper and then setting the conditions without seeing the individual. And I think that's why these criteria was set the way they were, because we wanted to make it for those first kind of individuals.
So the question is, how many people do, and maybe this is DOC, we need to get this number. How many people are being paroled presumptively? Because you wouldn't have those
Yes.
numbers, would you?
Yes, we would have those numbers because we have to set the conditions.
Okay.
So in 2024, we only had 4. I don't know. We haven't had a case yet in 2025. We're only 1 month in,
Well,
but
this went into effect January 1st, 21.
Yep.
And at that time for that year, that's the calendar year or fiscal year?
calendar year.
So it went into effect beginning of that calendar year. Okay. 12 people.
And the board can deny presumptive parole at their administrative review if they feel that the victim should be afforded the opportunity to provide input. And that's the only reason the board can kick a presumptive parole case to a hearing.
Well, we will continue seeing how this plays out.
Pretty small numbers.
Yeah, we were thinking there'd be high numbers. We really would be, because there's a lot of folks that meet the minimum and qualify for furlough.
It's gone down, right? So,
I think the
They
council,
can't meet some of the conditions.
oh, gotcha.
I think the Council of State Governments was projecting 35-ish cases.
Remember?
I think
it was around that.
35-ish, and then I know the population has, I think with the pandemic and the population has changed. And I think the other initiative,
Not numbers wise.
number wise, the type of individuals that are coming before the board, the crimes, the overall cases have changed.
So your minimum sentence is longer. Could be, or your risk factors are higher.
Right? Or those criteria just we're seeing more of those repeat individuals.
It'd be interesting to see the folks that were denied, those 4 in 21, if they wouldn't be coming up for presumptive parole in 22.
No.
I think the difference too, those 4 were probably people that had victims that had input
They would have had to.
and they had hearings, and they may still have been granted parole, but after victims had the opportunity to provide their input.
How confused are people? Sean?
So just to be clear, so someone a victim who
Yep.
goes there can just say, no, I don't want that person out about.
They can provide any input they want and the board will take that input into their decision.
Okay, gotcha.
And we made that a part of presumptive parole.
Yeah.
So that we do put in safeguards.
Important to hear from the victims,
Yes.
always.
It is getting clearer, but who decides whether furlough is appropriate or parole?
The OC does furlough. Parole, the parole board does.
Right, but somebody. See, that's what I'm still not understanding.
Sorry, I'm trying to lean down.
When a person reaches their minimum,
Right,
okay, two things. They can be furloughed. That's DOC that makes that decision. And there's tighter restrictions and
Right.
tighter supervision. They could, prior to that date of furlough, they could be presumed to be paroled if they were a good candidate and didn't have any violations of any of those 7 conditions. Also, what starts to happen at the minimum is if they're not going to be furloughed, DOC is saying, no way is this person furloughed. They could have a hearing before the parole board.
So per statute, I don't remember the exact citation. It is required at least 30 days prior to their minimum release date that they have an initial eligibility parole hearing. So at the same time DOC is doing release planning, whether it's on parole or furlough. At this point, because they're supervising the same level, I think we're seeing more recommendations for parole than furlough at their minimums. So they're looking at, everybody's coming before the board at their minimum. If they are granted, they're going to go out on parole. If they are not granted, then DOC is going to make the decision, are they going to place this individual on furlough or not, and release them to their plan.
Just to clarify for Kevin's question now that I think I get it. So the parole has priority and if it's denied, then possible for furlough?
Well,
Or does DOC get to say, well, we're putting on furlough and then you don't get to say, like, which one takes precedence?
so we have to see everybody per statute.
Yeah,
The timing of that is dependent on when we get the parole summary from DOC. Sometimes we get those we should be getting them at least 30 days prior to their minimum per statute. That doesn't always happen because credit can satisfy the minimum. There's other factors that come into play. So sometimes we may see them for their initial eligibility hearing when they've been released on furlough. But there's been a really big initiative to have people seen prior to their release on community. I'm going to call it community supervision as a whole, whether it be parole or furlough. Does that help a little bit?
which one takes precedence?
I don't think either one takes
Yeah.
precedence because they are both happening at the minimum release.
At the same
They
time,
at the same time, okay, I got
Yeah.
it.
I think
So
the
the
goal is to
department-
release them into the community. Whether the parole board does it or DOC does it
Right.
it's going to be the vehicle at the time.
And I think an important thing to remember too, and this is a big change, is that when they're released on supervision, they're being supervised by their risk level and not by their status. So someone coming out on furlough is not going to be supervised more strictly than someone coming out on parole. They're supposed to both be supervised according to their risk status.
not their
And
crime.
when we set conditions for parole, one of the things we look at is what are the risks that we're trying to address to keep the community safe, but also to make them successful while they're on parole. And corrections does that if they're setting furlough supervision as well. But by statute, as MJ said, when someone reaches their minimum, they have to be seen by the board. Now, they can waive that hearing, and occasionally they do. But generally speaking, we see everyone at their minimum.
I think we're gonna have to spend some time in explaining what risk. I see a lot of question
But-
marks on people's
but our-
faces.
yeah.
But our question, like from Kevin and I, is not about risk. It's, say you have a minimum of 24 months, you get to 24 months. Simultaneously, you're going for furlough and furlough?
Mhm.
Okay, so,
You could be denied parole, but DOC may furlough you,
right, but.
Or vice versa.
or vice versa.
Yeah, and it is starting to get clearer, but then why did we add the category of furlough?
We already had
We had-
furlough.
No, they're adding the
furlough was-
parole. Yeah,
We
there
had
is
lots of furlough.
Yeah.
Oh, yeah.
Presumptive parole.
Presumptive parole was the new one.
Furlough was a bit, an option before.
Parole
Yes.
was always an option.
And
We always had parole. We had a lot of different furlough statuses. We've always had probation. The thinking with presumptive parole is once you've reached your min and you qualify for furlough, instead of being on furlough, you will be presumed to be on parole because you wouldn't have as high supervision in the community as you would under furlough, and your violation of any conditions would go to the parole board, not DOC. So you're not clogging up DOC all the time. You're shifting some of that to the parole board.
And the goal, the long-range goal was to eliminate the furlough status. And to the extent that that can be done, there's been a lot of work in that arena from the Department of Corrections to lessen the number of people on furlough and have them be in a parole status when they're eligible.
Because other states don't have furlough.
Good, now I
Incarcerated
get it.
parole.
Took me too long.
So.
So now I have, so now we have, so now I have two questions. So you said that the goal of this presumptive parole and parole in general was to shift it from the general furloughing that we've been doing to parole. And so we're, sounds like disappointed that the numbers aren't what the council said that they would be.
Well, I think it's a little different than that. It's more about, there are cases that presumably would be granted parole and not necessarily have to have a hearing. And for those cases, we could move them forward a lot quicker. The interpretation of presumptive parole with the criteria that MJ mentioned that need to be satisfied, sometimes they're not there, so they have to have a hearing. But where there is someone eligible for presumptive parole and there's none of those criteria applying that would exempt them, they can be paroled. We just set the conditions if there's no victim input and they're on parole and there's not a hearing required. That's the big difference. I think the anticipation was based on the population when this was developed in 2020 and 2021 was that that number would be significantly higher, not by a large degree, but higher. And as it turns out, the population has changed a bit and those criteria affect a lot of those folks. So there's fewer of them, but when they do occur, it's a very simple process. The board gets a request from the department to consider this person for presumptive parole. If there's no victim issues, we set the conditions and the parole agreement is completed and it's done.
Yep. And then my second question is on the eligibility. There's seven points, and the last one says is not serving a sentence for committing a crime specified in 33 VSA 5204A. But we were just talking about how their legal status does not determine the risk level. But if it's not a crime that's in that, let's just say it's any other crime, but whatever's in that title.
Yeah.
Oh goodness, just blanked.
So what is 5204?
Yeah,
What is that?
It's the Big 10 or the Big 11
Big 11,
now.
okay.
It was the Big 12.
Okay, so I guess what I was asking is,
So we're.
let's just say it's,
Public safety.
if it's not in that big 11, it's just any other crime that they would have gone to.
Yep.
You're not going to take that into consideration when determining the risk level, because I feel like I would take that into consideration.
So I think-
Risk level.
I'm gonna talk about risk levels.
Okay,
It's not the crime.
it's not,
Right. And I think the risk, with presumptive parole, the risk levels coming into play when they're determining their supervision level. How many times they're gonna go check on the individual, how many times the individual is gonna come into the office. The risk level is involved in decision-making when there's a hearing. But with presumptive parole risk level, if they don't meet one of these 7 criteria, then they could be eligible for presumptive parole. And
So I think we're getting wrapped around presumptive
Yes.
parole and we're losing understanding of furlough and parole.
Yeah.
Okay, so let's let go of presumptive parole. Let's think real clearly furlough, parole. And I think one thing that
yes,
really needs to be clarified is what do you mean by risk level? Because I think that there is so much I don't want to say misunderstanding. It's just,
So when someone is released on supervision, whatever it may be, one of the things, the parole board, first of all, if they are granting parole, they will set the conditions for parole. And part of that process includes what is their risk. Their risk is based on a lot of things, not the least of which is what are the crimes that they're serving for. If it's a violent crime and there are victim issues, say a domestic violence case or a sexual assault or something of that nature, certainly protection in the public safety arena for those folks will determine the types of conditions that will be in play for them while they're on supervision. They're much different than, say, someone who has 3 DUIs. Not that that's not a serious offense, but the risks are more inclined to be, are they going to be driving a motor vehicle while they're impaired as opposed to assaulting someone? So we look at all the history and then when we set our conditions, we base it on our experience with those types of offenses. What is the best and least amount of conditions that we can put on this person so that they will be safe in the community and be successful? We don't want to overburden them with conditions, protecting them from the what ifs that may happen, but realistically looking at what is their risk, particularly related to the crime that they've been convicted of. And now that they're being returned to the community, how do we make them successful? How do we protect the public? And how do we determine the risk in each of those categories? And what do we do with that? That's where the setting conditions comes into play.
And I think to piggyback a little bit on risk, I think we're talking about risk in many different ways here.
Mm-hmm.
And I think that might be confusing too. So the Department of Corrections does a risk assessment, and that may be helpful. I can't educate you in that. They could. We no longer do our own risk assessment at the board. For years we did. Now we get the scores from DOC. They're the ones completing the risk assessments. That was one of the recommendations from the Council of State Governments and Justice Reinvestment. That's one factor that the board is taking into play. Then we also have a structured decision-making framework that we that we instituted through the National Institute of Corrections that 11 other states have instituted as well. That is a whole larger conversation. Be more than happy to share some information if that would be helpful on that a little bit more. I don't know if we have time today to get into all of that, but I just wanted to be clear, kind of to go off of what Chairman George was saying. Risk, I think risk can be interpreted in many different ways. There's the risk assessment, and then there's also what are the criminogenic need areas and what are those evidence-based need areas that's what we're really looking at in our structured decision-making framework and making the decisions.
If I may just interject. So from what I understood, and I'm just going to use this key word, history, you do take into factor the history of what someone did while they were in the facility. And from that, the crime they did commit, because we made the difference.
They're all
DUI and assault.
They're all pieces of that puzzle.
Okay, perfect.
And may I ask, of the Big 12, it's down to 11? I think I heard that.
I think I saw that in statute yesterday when I looked up that specific statute.
Can you remind me which one dropped off the list?
I don't know. I did not have time to compare. We're not part of,
That's okay.
yeah, I'm not sure.
I missed your question, but that's okay.
It's around the Big 12, how I went from Big 12 down to Big 10 or
Which one
11.
dropped off as
I don't
They might have
remember.
merged one.
What was it?
I think they merged one with a couple.
Yeah, I think they merged.
Oh,
You're right. I think they merged.
It's a very high profile, high victim.
More violent
Murder.
Gotcha.
Yeah, people crimes.
Yep, gotcha.
So risk, it's risk to reoffend, but it's also risk in terms of what are those triggers out there in the community that can trigger a person to start drinking or to be abusive or not comply with their conditions. It's not just the risk to reoffend. It's a lot
Risk
of,
to themselves.
yeah, it's a lot of different.
And there's a lot of community-based programming that the board mandates. And a lot of that doesn't take place until they're in the community, obviously. And so their participation and success in those programs helps with risk reduction, obviously.
If they have substance use disorder. You want to make sure they stay, if they're on the MOUD, you want to make sure they stay on that. That's a risk if they go off of that. So it's pretty broad. You're talking about risk. What's next?
So just real quickly touching on annual reviews, these are those administrative reviews I talked about earlier. In 2024, we completed 200 annual reviews, paper reviews of individuals who had been denied parole. 47 individuals requested in-person record reviews, so they have ability through statute to be seen once a year for an interview. And then we also completed 6 where the board looked at the record review and said, this person looks on paper, looks like they could be a good candidate for parole. We'd like to interview the individual.
And the parole board is made up of individuals who are appointed by the governor, correct?
Correct.
So it's just lay people. It's not people associated with Department of Corrections or Department of Mental Health. They're not state employees. They're not, I mean, you know, they're not working within the state necessarily. They're just lay folks.
Wow.
And it's your community folks.
With
A lot of training components that are required of board members. There's a huge commitment for folks that do this, and I'm really proud of the folks that have participated on the board in the last few years. And we've gotten a couple of new folks this year, and one of the struggles that we have, and I know our time is probably limited today, and there will be another opportunity to follow up on some of these issues, but we have 2 board members that started last year with us who both are working folks. And it presents a huge challenge for them to be available for hearings on a regular basis. And they do a great job of changing their schedules to try to accommodate the hearing needs and that kind of thing. But it is a challenge. And then to participate in the training, as MJ has referenced, the structured decision-making framework that we became involved in nearly 2 years ago, had almost a full year of training before we started implementing it. And we're now, along with 10 other states, in a group that are using this framework very successfully. In fact, in the conference coming up this year, MJ is going to be doing a presentation to the associations throughout the country on how the structured framework is working in a small state like Vermont.
That's just fascinating. The reason we would have lay people in such a critical.
So I think the statute does touch on a little bit of maybe having some justice system knowledge. But we have individuals on the board that have mental health background. We have somebody with a mental health background now. We have one corrections background, law enforcement backgrounds. One was a professor. So we just have different backgrounds on the board. And I think, as Chairman George said, it's hard to recruit for the parole board because of the nature of the work and that it's a per diem position during the mornings. And it's not, say, a night board where you can work full time all day and then appear for the board once a month at night.
What's the per diem amount?
Right now, it's $100 per workday.
$100 a day.
And we have 3 full-time employees, myself and 2 administrative employees.
Way too much responsibility for $100.
You gotta find money in the budget. It's DOC's budget that pays for it.
Yes, we are a line item in DOC, which also touches on another issue that we've been having around conflicts. Being that the board is an independent decision-making body, we are part of the DOC budget, and also we're struggling around our counsel. Our general counsel also is the supervising attorney for the DOC litigation unit. And that is a conflict.
That's a conflict.
That's a conflict of interest. And we tried over the last year to try to recruit our own conflict counsel. However, there was $25,000 that could be found in the budget that AHS would approve. And no one bid for the contract.
Too little. 25,000, you're not.
So that is one thing that we keep trying to tell, myself and the general counsel keep trying to remind everybody of this conflict because she's having a hard time balancing the autonomy of the board and the DOC issue she's facing as well.
That gets right into the weeds of how the
Yes.
general fund budget is established, because when the fifth floor, regardless of the administration, the fifth floor goes out to departments and agencies in August and September saying, keep your budgets to a 1% increase or level fund. And it goes out and DOC sees these pressures, but they're being asked to keep their budget growth to maybe 1%, 2% or level funded. This is how it all plays out. They may make a recommendation to the administration, well, the parole board needs X number more dollars, but the fifth floor may not agree with that in their budget. And then it gets presented to the appropriations committees, and then they make their case before the appropriations committee.
Right.
So there's this balance between having a budget that's affordable, but providing your needs. And then some people want to raise revenue and some people don't. Some people want more state employees and some people don't. And that gets all in the mix here, and that's how it plays out.
One of the things we really haven't touched on, and I think it's important just to quickly mention too, is parole violations, the parole eligibility hearings, which we spent a lot of time talking about, is really, from the board's perspective, the easier part of the job. The difficult part is the parole violation hearing process. And that number has gone up, and the complexity of violation hearings now has increased tremendously. Violation hearings begin with an evidentiary hearing where the board sits in front of the offender who's represented by counsel and the Department of Corrections who have their counsel, and the board makes decisions on the evidence that's submitted and then finds the person either guilty of violating their conditions that they've been accused of violating or not. If they have, then they move to a disposition part of the hearing where a discussion about what is going to happen to their parole status, be it revoked, continued with different levels of supervision, conditions, programming, changes in venue, a host of other issues. But those become very complex hearings, particularly when you're interviewing witnesses, and some of the witnesses are victims, and they have pending criminal cases that the courts have not had a chance to evaluate yet, but the board has to deal with it in many respects. We're getting some pushback on some of these cases because the prosecutors' offices would not like to have the victims testifying before us before they actually go to court in some cases. In other cases, they do. We bring the police officers in to give testimony. It's just a very complex process that takes a lot of time. And that number has increased, and it's also become much more complicated than they originally were many years ago.
So that puts a lot more pressure on your board, and then that I can see you're going to need to spend more time in training members on how to resolve it. And also, if people are struggling with a full-time job and being on the board, it all feeds in.
And it also links to that training issue too, as well. It goes back to with the council. Our council cannot come in and train the board on responding to violating behavior without a representative. I think we have to notify the Defender General's office, the Prisoner's Rights Office, of this training as it's in statute, and they can come and join the training because of this. An attorney it's specific to an attorney that also is an attorney for DOC. So that
Real conflict.
yes, and that's
DOC that violated them,
yes.
field office.
Yeah.
So
It's not good. Thank you.
So I just wanted to point out real quick on this violations, if you look at yes, the violation numbers have gone down since 2019, but I think it's the nature of the population. But I want to really focus on not so much the total numbers, but if you look in 2019, we had significantly more individuals who were revoked versus now more individuals are being continued on parole. It's really looking at the factors involved in these cases. And I think it goes into what Chairman George was saying about the complexity of the cases. And really looking at what are the needs of the individual, what are the release plans that are being posed at disposition. And the board puts a lot of time and effort in their decision-making to when they're deciding to continue somebody on parole or revoke their parole. And then the next slide, I wanted to just point out for last year, I really wanted to look at both the rates of continuing into revoking individuals based on if it's a technical violation versus a new crime violation, or both technical and new crime at the same time.
So we got some new members in terms of what is a
Sure.
technical violation?
So technical violation is any condition that they violated a condition of parole that does not involve the commission of a new crime.
So a condition could be that you don't use substances.
Right.
You don't go near a school.
You don't participate in your programming, you lost your approved housing, there's several different conditions. So if you really look at these numbers, more individuals all along each spectrum, we're continuing more individuals on parole than we are revoking their parole. And really, a lot of effort is in the technical violations of how to mitigate those technical violations to not return individuals for a technical violation.
And a lot of the public thinks it's new crimes. When you look at the numbers here, folks are circling back in more for technical violations for not carrying through on some of those conditions.
Yeah, and realistically, and we're trying not to circle them back in, because if you look, we continued 59 individuals on parole for technicals and only revoked 19. So there's a real strong effort in the board to look at the whole picture of the individual when making their decisions.
That's not to say if they come before the board 3 or 4 times.
Right.
And it's all been technical violations each time. Well, after a while, it's gonna be, hey,
Right.
giving you a chance
That's-
here. You haven't
That's what those
fulfilled.
19 represent.
Yeah, you're going back to the incarcerated setting.
Or the significance of what that technical violation was, and do they have a plan going forward? Some individuals just want to go back sometimes, unfortunately. They need that reset. And then hand in hand with the violations, so someone can be emergency arrested by DOC prior to, if they found that they violated a condition of parole and it warrants an immediate detention prior to the parole violation hearing, they can return somebody, just like they can with furloughs. And also, if somebody absconds, I can issue a parole warrant, an arrest warrant for that individual. So anytime somebody is arrested and lodged prior to a parole violation hearing, we have to hold a probable cause hearing if they are going to be held for longer than 20 days prior to their violation hearing. However, oftentimes, because individuals with violations, one other key factor is versus parole versus furlough is with a parole violation, the individual has the right to be represented by an attorney at the parole violation hearing. And generally, the Prisoner's Rights Office through the Defender General's office is that it represents the individual. So I forgot to make that key point in the last couple of slides. So a lot of times they will ask for a release hearing or a bail hearing prior to the parole violation hearing. So that's some of the numbers that you're seeing here. The contested numbers are those that involve, they're contesting probable cause. The non-contested are, they didn't contest probable cause, but they asked for a release prior to the violation hearing. And we have seen a steady increase in these over the last 3 years.
Do you have any indication why?
I think I know between 2023 and 2024, as we're having more individuals on parole and we're placing more out on parole out of the facilities, I issued, I want to say 20 to 30 more arrest warrants last year versus 2023. We're seeing more absconding of parolees.
Is it more numbers because more people have been released, or is it more absconding? It's not connected to the number of folks being released. It's just more
I think
behavior is changing.
the behavior is changing, but I think also we're seeing more, the philosophy, the board is now paroling more folks that are coming out of incarceration versus those that are already set up in the community. So I think that's a change too, is we are, before corrections was dealing with a lot of those, and because people are gonna violate sooner, if people are gonna violate, it's gonna be quicker after they're released from corrections and the correctional facility. And I think we're now dealing with a lot more of those than we did previously.
Because furlough was the
primary vehicle.
Yeah, it was the primary vehicle. So DOC was seeing it, not you.
Right. And I know we're coming up on time a little bit. There's one, I know there's other slides here, but there's one other thing, Dean, correct me. I'm gonna jump to victim testimony, because I think victim testimony is really big. Because I know victims, it comes up in many different forums. I know it's hot on everybody's mind with the earned time discussions and so forth. But I just, per statute, all victims of listed crimes must be notified of a parole hearing and given the opportunity to testify at a hearing.
Who does the notification for that? Is that the parole board or is that through DOC?
DOC does.
Through their victim notification system?
Yes, and
are you encountering any problems?
Oh, you want?
Are you encountering any problems with that?
I think they do it not just, I think they do it through the automated victim scans. And then I think they also do outreach directly if they have the victim. So there's two mechanisms the DOC is doing. They look in vans first to see if there's victim information. And if they don't have any, then they're reaching out to the state's attorneys, victim advocates to see if they have any contact information. And then the caseworker or the victim services specialist at DOC then reaches out to the victim either in writing or by phone and tries to contact the victim more personally. They're not just relying on vans for parole hearing notification.
One of the things the board instituted about a year ago and we're working with victim services is a form that gets included with the parole summary report. If there is a victim of record, what the contact information was, if they reached them, if they were unable to reach them, if the victim wanted to testify or not, or wanted to provide any information or not. So that gets included with the report, which saves us a lot of effort in trying to find out if the victim in fact was notified or not. We have this report that indicates whether they were or not.
The one thing I really want to highlight here in the victim testimony data is we've had a significant increase since 2019 in victim testimony. And I think there's a few factors that come into play with this increase. One is that we're online doing our hearings versus in person. So I feel like there's more of a safety mechanism built in for that individual. They don't have to go into a probation parole office. They don't have to go into a correctional facility, see the board. They can come online. They can be more anonymous.
They can block their
They can block their they can block their face. They can block their screen. They can even just listen to a hearing if they want to. Also, I know the Victim Services Division at DOC has expanded, I believe, some in the last couple of years. So there's a couple more victim services specialists. So there's some more capacity to work with victims and either speak on their behalf or just be with the victim as they're presenting to the board and supporting them through the process. And there's been changes to the policy with this form that Chairman George spoke to, really emphasizing how much the board values victim input and that they're looking at this.
We're gonna get into the victim notification system because I know House Judiciary is gonna look at that too, because there has been some issues within that. Is there a question? What are your challenges? And do you need legislation?
Well, I spoke about one challenge, which is around the attorney conflict. It's the conflict attorney, our conflict with our attorney representing both us and the Department of Corrections. That was one challenge that we're trying to solve. Dean, Dean, would you like to talk about our open meeting law challenge that we've been facing?
Yeah, and we had an
boy.
opportunity to meet with Chair Emmons on this before the legislature started, but during the summer months, we observed that someone was observing our hearings and learned that they were commercially producing a television show on YouTube, displaying the hearings and then having commentary along with them. There were a couple of cases where victims had given testimony and they tried to block out the victim's face, but did it rather poorly, and a couple instances where the victim's face was not blocked out, and the victim was clearly not being disguised in our hearings or anything. And so we became concerned about the use of this for a commercial purpose, and have been working with our attorney representative from the AG's office. And recently we've implemented some changes in our process. When we begin a hearing now, MJ announces that persons attending the hearing have to declare if they're there for a specific hearing and what is their purpose. Are they giving testimony or what have you? If they're not, are they a Vermont resident or not? If they're not a Vermont resident and they have nothing to do with the hearing, then we're not allowing them to observe the hearing for that reason. And so far that has worked very well. That has eliminated this person for the time being anyway, who felt that it was his right to be able to come in and produce a show with our material and go on from there. I don't know that that necessarily is going to ultimately solve the problem, but for the time being, it has limited access to just people who are interested in participating in the hearings for one reason or another, or who are Vermont residents and want to observe it. And then the last issue that we have a little concern about, and we've talked about, is the earned time thing. We still have some folks who do not wish to be considered for parole because they continue to get 7 days earned time per month when they're on community supervision furlough, which I'm sure we've talked about this in the past, but may come up again. That so we have somewhere in the vicinity of 50 people who have indicated at their initial parole eligibility hearing that they're not interested in being on parole because they don't get 7 days earned time if they're on parole. They only get that if they're on furlough or are incarcerated. So we're hoping to resolve that at some point. The board does grant early discharge from parole, and we talk about that. It's a merit-based program that the board has developed and has worked out really well for us as far as being able to discharge someone early from their supervision who was doing really well and met all the obligations that we set for them. But those are kind of the three big things that we're working on this year that are challenges for us.
Yeah, that was the biggie with why we were looking at expanding earned time to parolees. Because if you're on furlough, you do qualify for earned time. And the reasoning for furlough and not parole is furlough is under jurisdiction of DOC. DOC has control. You're still considered incarcerated when you're on furlough. It's just the walls have moved out to the community. When you're on parole, you're not considered incarcerated. So that's why when we put earned time in place, it is for folks who it doesn't apply to probation. It applies for folks who are incarcerated and folks on parole.
Did the Senate take that out? Didn't we have that in there last year?
For what?
Extending it to parole or time?
We,
They took it out.
they took it out, they took it
Yeah,
out,
'cause
and
we-
Justice Oversight to review. We're getting a letter from Justice Oversight saying it's problematic. Dealing with the victim notification system. That's the issue.
Right.
Um. So. Do you think it would be just worthwhile just to extend current time to parole, period, just like it is for incarcerated and furloughed folks?
You know, as long as it's not an administrative burden for us, if it just gets put in play, it has no impact on I just feel bad for the folks that are choosing not to be on parole supervision, because it is to their credit. If they're successful, they can get done their supervision early. I think a criminal history check when someone is successfully on parole and goes through their sentence is a much better look than someone who does not. But that's a choice that some are making because they see they don't have to do anything to earn this, basically, and 7 days a month can be significant if you have a long period of supervision ahead of you.
I've also been doing a lot of thinking about the victim piece as well, as all the victim discussion came up towards the end of the session last year and this summer. And with that, when somebody is sentenced, sentenced to an incarcerated sentence, they receive that sentence. They're presumed that they're going to be receiving earned time while they're incarcerated, and then when they're released, if they're on furlough, they continue that. So it's kind of, the victim knows at sentencing, they're getting 7 days off their sentence. Parole is still an incarcerated sentence. They're still serving that same sentence. So to me, it would only make sense for continuity for the victim that it either stop when they're released into the community, whether it's furlough or parole, or it continues through the end of the sentence. Then that way, I think it's less confusing to the victim of, wait a minute, now they're on parole, they're not getting their earned time anymore, so their sentence and maybe. I think it's really looking at trying to make it less confusing for the victim, and I think that's where it can be confusing. Yeah, when it's switching back and forth.
It's a re-traumatizes the whole situation on it.
Because if somebody's so if somebody's released to parole and then they subsequently have their parole revoked for whatever reason, they are now eligible to start earning their earned time again once they are reincarcerated. So I think that's confusing as
It's a calculating nightmare for
Yes.
DLC.
Yeah.
absolutely.
And I'm embarrassed to say this, but you're using the word victim for the incarcerated person.
No.
No.
Okay, so I guess I.
Victim of the
The
crime.
victim of the crime,
Right,
yeah,
okay.
sorry.
So I missed what you
I'm
said.
sorry.
The victim is counting on.
So when somebody is sentenced, the victim finds out this is what the individual sentence is. So will find out what the minimum and maximum release date is. And then they can do some calculations in their head of what 7 days each month would be.
Okay.
However, if that's stopping along the way or then restarting along the way, it just gets even more cumbersome for the,
Determine when the individual will be.
when are they gonna actually be done?
And then we also, when we put in the earned time, we were very clear that victims would be allowed to be notified
If they want.
if they want, because so if there's a change to the person's earned time, the victim could be notified, but the victim's in the driver's seat.
Right.
On that. So every time there's a change, like what Mary Jane was saying, if the person's on furlough, the victim would be notified that they're going to be released on furlough. Then if they violate, they're back in corrections, but if they're released on parole, there's no earned time that's calculated, but if they end up back in corrections, earned time kicks in again, so then the victim, could be notified. So each time there's a notification of the victim, they relive the whole situation all over again. So we've been very sensitive to that, to make sure that there's a balance there, that they're notified, but not re-victimized.
It would be really helpful to have it just be consistent throughout. particularly for domestic violence victims. It's hard to explain to them the process and make them understand that it's in their best interest too. And many times we don't believe it is either.
So we've spent a full afternoon here on parole. I hope it hasn't been too confusing for folks. I hope it's
Excellent.
been
Thank you
helpful.
very much.
Dean, I
Thank you
want to
for what you do.
thank you for coming in. And
Oh,
Dean,
my
as I
pleasure,
said,
always.
was a former member. He served on Judiciary Committee, I believe.
Yes, he did.
And also, I'm going to say this, he was also a state police officer.
Yes, he was.
Thank you.
Well, thank you,
Just for
Chair.
30 years.
Yeah.
Yeah.
He retired from being a state police trooper, an officer. He came into the legislature. And I forgot how many years you served, but you were a real
I was,
asset.
yeah, retired as a captain
That's
after
exciting.
30 years. Yeah. Great career. I'm not sure I'd want to do it today.
Oh, and how long were you in the legislature?
Just one
Six?
term.
Was it just one?
Yeah. I was 20 years on the select board, but only one term in the legislature.
Oh, you were there longer than that. Wow.
I was thinking it was 4.
Yeah, I was thinking it was more than
This
that.
is my 20th and probably my last year on the board, though.
Yeah.
Oh, no, you can't do that.
You gotta train your
Yeah,
successor.
that's right.
Yeah. Well, thank you, Dean. Thank you, Mary.
Thank you both.
Really appreciate it.
Congratulations for speaking nationally about what we do.
Oh,
Awesome.
I've been on the, I was actually appointed to the executive committee for the Association of Paroling Authorities International. I'm the
Oh,
Northeastern vice president for that
Wow.
association.
How long have you been on the parole board?
6 years.
Wow.
I was with corrections 12 and a half prior.
Congratulations or condolences.
Yeah.
Yes.
Oh, no, it's a good organization and it brings a lot of, that organization has been really helpful to Vermont and really bringing us up to standards.
Great. Well, thank you both.
Very good.
I'm sure we'll each other.
Bells are ringing.
Yes.
We give a little bit of time.
Let's get off of Zoom here, Zoom and YouTube.